All right, we're continuing with Nathamer v. Brenneman Property Services, Inc. All right, so we went over the facts, and we talked about what was at issue in the case, and let's go ahead and look at the legal standards. So just to establish discriminatory intent under the Fair Housing Act, the plaintiff would need to establish a prima facie case of discrimination. Once they did that, then the burden shifts to the defendant to prove a legitimate, non-discriminatory reason for his conduct. And if the defendant meets that burden, then the plaintiff must show that the reason is mere pretext. So that is what the plaintiff was trying to do in this case, right? So although he did not have any direct evidence, we said the plaintiff was able to show the first two elements of the case, that there was a factual issue and that there were two remaining elements. And the plaintiff argued that he established a prima facie case, and that then the burden shifts to the defendant. So this case was brought under the perceived disability section of the FHA, and the court found that requiring the plaintiff to show definitive proof of the defendant's perceptions at the summary judgment phase would create an impossible burden of proof. What they did find was that there were enough, quote, clues to allow for a reasonable jury to conclude that the defendant suspected that the plaintiff was infected with HIV or AIDS, and that was based on the plaintiff informing the defendants that his lover had died of AIDS. The second element, which was whether or not the plaintiff was qualified for the property due to his credit records, the court found that there was a factual issue here, that although his credit was poor, they knew that the credit was due to a one-time medical catastrophe, that he had significant assets in the bank, that he had a credit reference, and that he offered to prepay 1 year's worth of rent. So, based on this evidence, the court found that the plaintiff had provided more than sufficient evidence to then shift the burden over to the defendant and to survive a summary judgment at this point. Now, note that this case was brought under the FHA, under the handicap definition, because the FHA does not protect against discrimination based on sexual orientation, although the DC equivalent did protect. So when you get a fair housing case like the one we just reviewed, you're going to want to look to see first if the property is exempt from fair housing. And I mentioned briefly in the previous video what these exemptions were, and here they are on the slide. The exemptions apply to two types of property, which we went over earlier, but neither one of these exemptions applied for the Nathamer case. We already discussed why Congress might exclude those exemptions, and now we're going to talk about the FHA hypotheticals. A quick note about the difference between the Civil Rights Act and the Fair Housing Act before we get into these hypotheticals. So if you want to take a look at the Civil Rights Act of 1866, it's on page 449 of your textbook. Both the Civil Rights Act of 1866 and the Fair Housing Act are similar in that they prohibit racial discrimination in the connection of the purchase, sale, and leasing of property. So how do they differ? Well, the Fair Housing Act covers 7 different types of discrimination, but it only applies to the selling, renting, or advertising, and it only applies to one type of real property, which is called a dwelling. The Civil Rights Act of 1866, on the other hand, it covers only one type of discrimination, and that discrimination is racial discrimination. So it does not cover other types of discrimination, like discrimination based on gender. So although it only applies to racial discrimination, it covers more types of property and more types of conduct than the Fair Housing Act covers. So the Civil Rights Act of 1866 covers conduct like inheriting, holding, and conveying property. But it does not cover advertising. Advertising is covered by the Fair Housing Act. The second way that the Civil Rights Act is different is that it covers all types of property, not just real property. So the Fair Housing Act covers real property and it covers dwellings. But the Civil Rights Act covers all types of property, real property and personal property as well. Okay, let's get into these hypotheticals. Hypothetical 1. You can find these on page 450 of your textbook if you'd like. All right, A's website notice is number 1. We're going to answer the question whether or not the Fair Housing Act or the Civil Rights Act have been violated in any of the following hypotheticals. So A posts a notice on a website that says, for rent, 1-bedroom apartment in a 10-unit building. Prefer tenant who can speak French or German. Is this notice a violation of the Fair Housing Act or the Civil Rights Act of 1866? The answer is yes. This is a violation of the advertising provision of the FHA. And it violates it because it is an intention to make a preference based on national origin. Now, this is not a violation of the Civil Rights Act because the Civil Rights Act does not cover advertising. All right? Hypothetical number 2. B, a black woman applies to rent a single-family residence owned by C. C tells B, I won't rent to you for 2 reasons. You are black and female. Is this a violation of the Fair Housing Act or the Civil Rights Act of 1866? Let's start with the Civil Rights Act. This is a violation of the Civil Rights Act because it's a refusal to rent to B because of her race. Now, this is likely not a violation of the FHA because it falls within the exemptions. So the property involved is a single-family residence. and no realtor, based on the facts, appears to have been used. And so this would be a violation of the CRA, but not the FHA. All right. Hypothetical 3. D, a mother with 4 minor children applies to rent a 2-bedroom apartment in a large complex. E, the building manager tells her, you have too many children for an apartment that small. Let's assume that E then refuses to rent to her. Is this a violation of the Civil Rights Act or of the Fair Housing Act? So D can establish a prima facie case under the FHA based on familial status, right? And this would then shift the burden to E to show a legitimate non-discriminatory reason as to why he refused to rent to her. So it would then depend on the facts as to whether or not D could provide an adequate reason. It would probably be based on housing codes and how E typically handles this type of situation, right? So if he would have rented it to another family, let's say that had 2 adults and 3 children or 5 people, then of course here we would you would have a better case to argue discrimination in the case of D because of her children or because of her familial status. There is no violation of the CRA here because E's refusal is not based on race. All right, so likely at least a prima facie case under the FHA here, and no case or no violation of the CRA or the Civil Rights Act. All right, hypothetical 4. F, who owns a duplex, places this ad in a local paper to find a tenant for her vacant unit. The ad says, female tenant wanted for apartment near university. F lives in the other unit. Let's start with the Civil Rights Act. The Civil Rights Act does not apply here, and there's 2 reasons why. The first is that the Civil Rights Act doesn't cover advertising, and this is a case of advertising. And the second is that the Civil Rights Act doesn't cover discrimination based on sex. It only covers discrimination based on race. So the CRA does not apply here. The ad does violate the FHA's regulation. The subsection C that prohibits discrimination based on sex. Now, note that the property is not exempted here. Why? Well, because the exemptions are only available for A and B of the FHA. The subsections A and subsections B, not subsection C, which applies to advertising. So the exceptions don't apply for advertising. So again, the ad does violate the advertising provision of the FHA in section 3604, subsection C, in that it expresses a preference based on sex. All right, our last 2 hypotheticals on the FHA and the CRA. Hypothetical number 5 is G is a confirmed vegetarian, applies to rent a studio apartment in a 5-unit complex owned by H. H refuses to rent to G because she is a vegetarian. Do we have a violation of the FHA or of the CRA? Well, here CRA doesn't apply, right? Because it's not based, H's refusal wasn't based on race, so CRA doesn't apply. Right, the FHA would not apply here either. Although the property is not exempted because it's a studio apartment and it is a dwelling, it's not otherwise exempted, but being a vegetarian is not one of the 7 protected categories under the Act. So it would not be a violation of the FHA. All right, hypothetical 6. J, a Hispanic male in good financial standing, applies to rent a 1-bedroom unit in a 200-unit apartment tower owned by K. K refuses to rent to J, giving no reason, and the unit is still vacant. Is there a violation of the Fair Housing Act or the Civil Rights Act? All right, so J probably has a claim under the CRA and under the FHA as well. So J will be able to establish a prima facie case for discrimination under FHA, which would shift the burden to K. K would then have to prove a legitimate non-discriminatory reason for refusing J's application, and K would likely not be able to show that. So, especially because if you look at the fact pattern, K did not give J any reason for refusing to rent to J. Okay, one more hypothetical just to set up the next case. Let's say a married woman with children, has to rent out rooms in her house while her husband is deployed. A man approaches her to rent the room. Can she refuse to rent it to him based on the fact that she does not want to rent to a man? Or would that be a violation of the FHA? Likely, she would, yes, be able to refuse to rent to him. Why? Because it is an owner-occupied dwelling, and she's not using a realtor to rent the house. All right, so what if she wants to advertise the rental on Facebook and have it say no men allowed? Well, what do you think the result would be? Well, to answer that question, we would first need to look at the language to see what constitutes a dwelling. Okay, it's a bit difficult to read here, but I pulled this off page 455 of your textbook. So, what is a dwelling under the Fair Housing Act? The Fair Housing Act defines a dwelling as any building, structure, or portion thereof which is occupied as or designed or intended for occupancy as a residence by one or more family. And family does include a single person. So based on the plain language in the statute, should FHA apply to situations where someone is looking for a roommate? Well, based on the plain reading, it would seem to include sharing rooms because it says any portion of a building which is occupied as a residence. So that, just from reading the statute, that would seem to include sharing a room or sharing a house. So let's take a look at the Ninth Circuit's interpretation of a actually similar situation. So the case is Fair Housing Council of San Fernando Valley versus Roommate.com. And the facts of the case are as follows. Roommates.com operates a website that helps roommates find other roommates. And as part of the process, roommates.com asks the users about their sex, their race, their sexual orientation, their family status, as well as other personal characteristics in an effort to help them find roommates or match roommates. Roommates or users are then able to search their roommates.com's database in order to find who they consider to be a match. The Fair Housing Council and a sister group sued on the theory that these actions by roommates.com violated the Fair Housing Act, and the district court granted summary judgment in their favor. So the court is now trying to determine whether this ruling of the lower court was correct. So we are applying the Fair Housing Act. And the court begins their analysis by asking, is a shared living space a dwelling under the Fair Housing Act? So we analyzed the plain meaning, and it seems to suggest yes. But the court found that the statute, the Fair Housing Act, was ambiguous. And they said that it reasonably could be read either to include or exclude shared living arrangements. So because it was ambiguous, they looked at congressional intent, and they found that there's no indication that Congress would have intended to, in the 60s particularly, to allow or to prevent a woman, for example, from refusing to accept a man as a roommate. The court then goes into an analysis of the right to associate. And they suggest that if the court was to interpret the Fair Housing Act to apply to activities inside the home, then it would violate the right to associate, which is a liberty that's protected by the Bill of Rights. It goes through the case law. It finds eventually that it extends the right of intimate association to roommate relationships. They suggest also that Congress could not have meant to interpret or intrude on this liberty, this right to intimate association, or to choose who to associate with or who not to associate with. Therefore, the court holds that Congress did not intend for a dwelling to include rooms within a home, but rather only independent dwellings. So they hold that the Fair Housing Act doesn't apply to the sharing of living units. Now, it's important to note that the court also justifies their decision based on constitutional concerns. So they argue that if they interpret the statute to include the sharing of living units, then they run the risk of a constitutional challenge based on the right of intimate association. Let's unpack this decision a bit, shall we? So there's really two primary points of discussion in this case. And the first is whether Kaczynski's interpretation of the statute was correct. Did the court correctly interpret the Fair Housing Act? The second question is, was there a justifiable policy outcome as a result of the case? So let's start with looking at the court's arguments to see if the interpretation of the statute was correct. We can start by really asking, did the actions really implicate the right of intimate association? Okay. So in the past, cases have found that to qualify as an intimate association, the relationship needs to be highly intimate, highly intimate. And the types of relationships that were found to be highly intimate before this case were relationships with family members or sexual partners. Now, is the relationship with a roommate similar to that of a family member or a sexual partner? Think about it. If roommates were considered to be highly intimate relationships, then wouldn't we have to extend the definition of highly intimate relationships to close friends? What about business partners? So courts in the past have been hesitant to interpret highly intimate relationships to include friends. And so was Kaczynski correct in interpreting it to include roommates? I would argue, and other scholars have argued, that Kaczynski's interpretation seems to extend the right of intimate association in ways that were not supported by the previous case law. So, did the court see a constitutional issue in this case where there wasn't one? It seems that the answer to this would be yes. Now, the court may have gotten stuck on the hypothetical that they posed that when trying to interpret Congress's intent, they said that Congress in the 1960s could not have possibly intended for a woman to take a male roommate. Maybe they got stuck on this hypothetical and tried to fit the case law to their end goals. But let's look at what the costs of this interpretation were. So, what are some of the practical implications of the rule? Suppose that X is looking for a roommate. Based on this case, could X refuse to rent to an African-American applicant because of race? The answer is yes. Kaczynski says that it's not illegal to discriminate in selecting a roommate. All right, well, could X refuse to rent to a Christian because of their religion? Again, here, based on Kaczynski, the answer is yes. So, the problem with this decision is that it results in allowing discrimination for roommates, even if it might not have allowed that discrimination for other. It allows for discrimination for roommates. Sorry, lost my thought there. Okay, so how could the court have ruled differently? The court could have looked at the plain language of dwelling like we did and said that the based on the plain language that a portion of a house is a room, and so FHA would apply. So the Fair Housing Act, they could then have had a near ruling that the Fair Housing Act prohibited discrimination in advertisement for roommates or of shared living spaces. So they could have limited the decision to advertising. That would have been different than limiting the decision to the right to associate, right? Because we're only talking about advertising here. We're not talking about whether or not an individual who is in an owner-occupied unit is going to rent out the place, because remember, those are exceptions to the Fair Housing Act. The second option is that the court could have still found that the language of dwelling was ambiguous, but instead of going down the line of arguments that they went, they could have looked at the statutory purpose of the act to help them in interpreting it. And the statutory purpose was to combat housing discrimination. That concludes creating a tenancy.